Good afternoon, and welcome to the City of San Jose's webinar series for COVID-19. My name is Sandra Freitas, and I will be facilitating this afternoon's webinar on Employer and Employee HR Toolkit in response to COVID-19. Today's webinar is being recorded, and it will be posted for public viewing. Thank you for joining us today. I would like to take this opportunity to thank our business owner space partners, U.S. Small Business Administration, Downtown Willow Glen Business District, Latino Business Council of Silicon Valley, Small Business Majority, LISC, Silicon Valley Black Chamber of Commerce, Silicon Valley Organization, Small Business Development Center, Hispanic Chamber of Commerce, Silicon Valley, Winchester Business Administration, San Jose Public Library Works, SCORE, Silicon Valley, eBay, Start Small, Think Big, Nextdoor, Facebook, and Opportunity Fund. Today's agenda will be focusing on orienting you on how to record your questions, comments, and inquiries, introduce you to two guest speakers, share upcoming webinars, and at the end, we'll ask you to complete a survey. As a quick overview, all participants will be placed on mute for the entirety of the presentation and will be invited to speak during the Q&A session, which will be addressed after the presentations. Please use the Q&A function located at the bottom of your screen to scribe your questions. If you have any questions pertaining to loans or any other topic that does not pertain to this afternoon's presentation, please email or visit our website for resources that are listed on our site at sjeconomy.com/COVID-19 business info. Once again, that is COVID-19 SJ Business at sanjoseca.gov. Vietnamese and Spanish reading staff are reading emails, so feel free to ask questions on those language if you feel most comfortable. In the event you need to leave while the webinar is in session, please email your question, inquiry, or concern and someone from our team will get back to you. Our email address is listed here and on the resources slide. Once again, if translation services are needed, someone from our team will be happy to assist you. Today we have two guest speakers. Our first speaker is Greg Torrico, Program Manager for Start Small, Think Big. Our second guest speaker is C. Edward Langhammer Jr., member with Cozen O'Connor. At this very moment, I'd like to ask Greg Torrico to present on Start Small, Think Big.
Yes, thank you so much, Sandra, and just generally the City of San Jose as well as Ed for sharing in this space related to really a timely topic given what we are seeing in this very moment with the pandemic. So I'd like to share just a little bit about the nonprofit organization that I work with, Start Small, Think Big, so that folks know after Ed's presentation, ways to connect with legal assistance and legal advice, especially for business owners in this current time. Sandra, I'm wondering if you are able to just pull up my slides. I'm happy to wait on you a little bit.
Go ahead. You're very welcome.
So next slide, please. Great. So again, Start Small, Think Big is a nonprofit. We have an office in New York with 2 offices in Oakland and San Jose. I manage the San Jose office, and our mission really has to do with allowing business owners to access high quality legal, financial, and marketing services, especially as we know that this is an essential part of growing a small business. We really look to support underserved small business owners, and we really want to be able to provide as much information and resources as possible. Next slide, please. And so we do this in 3 tiers. We do this through legal assistance, financial, and marketing assistance. You know, the ways that this shows up is obviously providing space for attorneys like Ed and firms who have information that relates to business development to do free legal webinars on a regular basis. So this is one of the many ones that we have done in the past and the ones that we hope to do in the future. We also provide technical assistance to business owners by way of connecting them to you know, the different matters that the attorneys can actually support in. That includes anything from legal structure to contract review, commercial lease, and the like. We definitely try to provide as much technical assistance as possible. The same with financial and marketing assistance. We do try to connect, again, business owners to our financial team so that there's conversations around general financial management as well as bookkeeping. And then marketing, again, as we're pivoting into a digital world, we want to make sure business owners and businesses in general have a really good and strong social media presence. And so we do everything in our power to make that happen. Next slide, please. And so one way to get access to our services for free is to qualify through our eligibility criteria. This is one of the ways that shows up. We're looking at business stage businesses, again, operating businesses so that you're selling goods in the last 3 months that equal or are greater than $500, and that your business revenue does not exceed $1 million. We're also looking to support business owners who, again, are part of traditionally disadvantaged groups. And we also look at federal poverty guidelines. Again, your household income cannot exceed 500% of federal poverty guidelines. And this is some of the ways that we could actually, again, allow access to these free services, which are so important in this moment. Next slide, please. So what are we doing with COVID-19? Next slide. One of the ways that this pandemic has changed our organization is really understanding the ways that we can provide and expand our resources beyond our traditional physical offices. Again, I mentioned that we are in New York. We're also in San Jose and Oakland. Previous to the pandemic, we were supporting people face-to-face. Obviously, the pandemic has changed all of that. We've done everything remotely, and that has allowed us to also expand across the country. We have started what is called the Rapid Response Project. This project allows business owners to connect to free financial and legal advice as it relates to matters of the pandemic. So for example, you're a business owner, you want to talk to somebody about a lease because you're in a situation that is pretty precarious with your landlord. You want to have that reviewed. You want to know what you can do. We can connect you to free legal advice to make that, that decision a little bit easier. So anything that is related to the pandemic that is, again, within the context of finance and legal, we can definitely support you. And there is no particular criteria for this. The only thing you need to be is a business owner. Next slide, please. And so again, just some FAQs for you to know, and I'm sure that this is also going to be shared later on as a recording as well as the actual slide deck, so you can keep this on hand if you want to return to it later. Very briefly, it's just, again, a business owner who has legal and financial questions. The assistance is free. Again, that's completely free. There is no catch here. And we want to make sure that you are able to get supported in this moment. All you need to do is apply using our application that I'll share in a moment. It is in English and Spanish as it relates to Spanish-speaking clients and folks who are in business. We look to hopefully support you through an interpreter. And so, again, you're not going to be precluded from this program because you don't speak English. We can definitely support you with that. And the same thing is true if you're undocumented, if you're a business owner who, again, does not have status. That is not going to preclude you from obtaining this information. Next slide, please. And so next steps, if you want to become a client, you can definitely follow our links there. It's English and Spanish in terms of trying to access our full range of services, which would, if you're a client, you get these services for 12 months. If you are looking more for urgent response because of the pandemic, you can follow those links, again, English and Spanish. And finally, you can see our webinars. Anything that we've done is always on our website so that you could also access that on demand. Next slide. We do have an upcoming webinar in Spanish that I just wanted to share in case folks are interested. It is related to the PPP program, and it is going to be taking place next Tuesday. Again, it's going to be bi-coastal, so we'll have it on California as well as Eastern time. You can register there. It'll be Facebook Live through the attorneys that will be supporting us, Cleary Gottlieb. So feel free to jump on if you're a Spanish speaker or you have Spanish speaking business owner friends that want to, you should let them know. Next slide. So again, my name is Gray. I'm excited to hopefully support any of you. And if there are any questions at the end, feel free to let me know. And you can also reach me at that email. So with that, I will turn it over to either Ed or Sandra, who will move on the presentation. Thank you so much.
Great, and thank you so very much, Gray. Ed, we'd love for you to share your screen at this very moment.
Okay, so hello everybody. Thank you, Sandra, and thank you, Gray. Sandra, just housekeeping. Are we able to see the presentation?
One second, I can see your presentation. Hi, Ed, just wanted to confirm your presentation is up and viewable. So you may begin presenting.
Okay, great. Well, hello everybody. Thank you for letting me talk to you this afternoon. The title of the presentation is Employer and Employee HR Toolkit in Response to COVID-19. And I have to say, I've been practicing law for a long time, and never in the more than 35 years that I've been practicing have we had so many different things hit us all at once with respect to things that weren't even on anybody's radar 4 months ago. I mean, an entire system has now been put in place and will continue to exist. So I'm delighted to share with you. I'm here to talk about the human resources toolkits. One of the things we'll talk about are model forms, policies, and templates for employers. And I will share with you that these have been developed by my firm. I'm resident in our Santa Monica office. We have offices in San Francisco, Los Angeles, and San Diego, in addition to having offices all across the country. And this development of these resources has been a massive effort from everyone in my firm. All of our lawyers practicing in labor and employment have all pitched in to not only to do these presentations, but also to develop forms. And also share with you that these forms will be available as templates for you. We'll talk at some point or at the end about how you might be able to access those. But we try to cover the landscape between workplace policies and forms, responding to exposures in the workplace, medical screening and testing, furloughs and recalls, accommodation requests, and then the Families First Coronavirus Response Act. So we have a series of new things that have come up as a result of the pandemic, but we use, as lawyers, we're still using our traditional tools on how to deal with things. And we'll talk about that. I mean, these are all new challenges for all of you running your businesses, and it's been an amazing last four months since we really started talking about this. But just for a quick overview, what we're going to talk about today are social distancing and employee hygiene policies. We're going to talk about protocol for responding to a positive test case. We'll talk about employee medical screening forms and policies. And then we'll talk about request for leave and accommodation request forms. That's our roadmap. So first we'll start with the social distancing and employee hygiene protocols. Now on this, I'll say right off the bat, this is not, what we're talking about is this is not a one-size-fits-all solution. There have been so many, so much guidance from so many different federal agencies, from the state agencies and from our local agencies, that these things are all going to continue to evolve, and as we move along, the policies are going to be dynamic. And what we mean by that is there's going to be a lot of changes still that's going to be coming along on this. But one of the baselines is for companies who are dealing with this stuff, one of the big issues is to have your communications with respect to what you're doing and any changes that are made. You want to make sure you have these in writing. It helps to give you certainty, helps you give your manager certainty, and also helps to give your employees certainty. So on distancing policies, what we want to include are a number of elements, but they include things like individual workspaces. There's making sure that there's an appropriate amount of space. One of the big issues that comes up in a lot of companies are meeting in shared spaces. And what we mean by that are, I mean, for example, in my business, one of the big issues are, one of our huge shared spaces is, of course, our conference rooms. And then, of course, the most critical shared space is our kitchen that our firm has, because that is the classic example of what our shared spaces are. There have been, I just mentioned in passing that that San Jose just released their alfresco policy or guidance that just came out on June 5th. And those rules are designed to help businesses serve their customers. And of course, many of you probably already know this, those of you who have businesses, that as of June 5, the county has allowed certain businesses to open. They're going to include elements like outdoor spaces, use of private property, implementation plans, registration requirements. So these are going to be some of the continuing evolution of policies and procedures, including these distancing policies that we're talking about. Another big piece of it is, and we've been living this for several months now, but is to, for companies, one of the things that's still important is to encourage employees, your customers, your clients, to engage in good personal hygiene and infection control practices. And we're going to talk about this and what this means when you're in the workplace. We're going to talk about personal protective equipment, and that includes cloth face coverings, that include masks, it includes masks and face coverings that can either be store-bought, purchased, or made at home. And the CDC guidance, the Center for Disease Control guidance, just wants us to make sure that the cloth coverings are effective, that they fit snugly but comfortably against the side of the face, that they're secured with ties and loops around the ears, that they include multiple layers of fabric, and what's critically important, allow for breathing without restriction, and should be able to be laundered. They should be able to be wash and wear. And we'll talk a little bit more about face masks, but there are some other things that companies need to be concerned about and need to deal with if employees are required to wear coverings, face coverings or masks in the workplace. So we're also going to talk about basic hand hygiene. Wash your hands, 20 seconds. It's the stuff that we've become very familiar with. And then avoiding surface touches. So with respect to masks, there's a little bit of a explanation here, because when we're talking about a mask, you've heard mention about N95 respirators, and those are actually considered to be respirators, not really masks, but they are a specialized medical grade or surgical mask that are worn by healthcare providers, first responders, workers in other industries. So the Center for Disease Control recommending that those masks not be used by regular employees. Now, I'll add one caveat to that, which some health authorities have talked about, which is if, as part of reopening our workplace, you're going to have employees that may be high risk. And high risk can mean a variety of things. It could be a medical condition. It could mean over a certain age. It was 65, but it may actually be 70, in your 70s and your 80s. But again, that have a health risk. Because there's now a train of thought in the medical profession that if an employee, if anyone for that matter, is going to use public transportation, then if an N95 is available, they provide a better level of protection. And that's all I'm going to say about that. But again, we're going to have face coverings, which can be a cloth, a bandana, a handmade mask. We already talked about it should fit snugly, it should be secured. Has to allow for breathing without restriction. And we'll talk about breathing a little bit because that's going to be another important issue. So here's a big issue. My clients are asking this question. And the answer is, the question is, can you require employees to wear a face covering? So the short answer is yes, that an employer may require employees to wear protective gear, which includes masks and gloves, and candidly observe other infection control practices, hand washing, social distancing. But here's the second piece of this, and it has to do with whether an employee has some kind of a disability. And because of that disability, there may be a need for an employer to provide a reasonable accommodation under the ADA, that's the Americans with Disabilities Act. And that includes things like non-latex gloves if an employee has an allergy, modified face masks, for example, for interpreters or others. And for folks that are hearing impaired, it can be challenging. I mean, if they lip read, it's going to be challenging to communicate through a mask. And then, of course, the gowns designed for people that use wheelchairs. And then we have a religious accommodation. So what I'll say about this is that a company doesn't have to provide a particular reasonable accommodation if it poses an undue hardship. And that means significant difficulty or expense. And that means, though, the company has to consider whether or not there's a reasonable accommodation that can be made, which would not impose a reasonable hardship. And of course, now this is different. Everything's a little bit different now, because if something wasn't an undue hardship prior to the pandemic, now could actually pose an undue hardship now. So there's a lot of play. We'll talk about this a little bit more a little bit later, but the point is that in almost everything we're talking about, there's a high degree of employers and employees needing to be somewhat flexible in their requests, demands, how it's actually working in your particular workplace. It's, as I said before, one size doesn't fit all. And it is necessary for everyone to have a certain amount of flexibility and not get locked in on some of these issues. So one of the big questions always asked is, well, what happens if the employee refuses? And it depends, because if it's for a medical reason or if it's for a religious reason, then in that case, then the employer has to engage in what we call an interactive process. And that the process is to talk. It's a face-to-face conversation in a perfect world, because it really is a process that's designed to determine whether or not and to what extent an employee can be accommodated. And so if it's for a non-medical reason, then the employer should still engage with the employee to determine, why is there concern? Is there an underlying, a protected reason, which means a legally protected reason that if you deny it would be discriminatory? And one example of that is certain religions have dressing grooming requirements. And so that's just one example, and there are many, many other examples. There's also just a lot of pushback on, there seems to be a fight now, there certainly is in some counties, with respect to whether or not an employee should be required to wear a mask in the workplace or out on the street if the employee doesn't want to. And for example, in the county of Orange County, which is a county down here in Southern California, there was a mask order that was put in place in late May, and the health director faced immediate challenges to it. And there were apparently death threats, and there's some other things that went on. And there was just a camp of people. There were just two groups of people, one saying, yes, wear a mask, and the other one saying, no, we don't want to wear a mask. And so there's, you're likely to see this in your businesses, because it seems to be an issue that is now coming up. There's no easy answer. I mean, it's a political issue. It's a for us as running our businesses and focusing on our businesses, for us, it's a safety issue. It's a health and safety issue. But what you have to do, or what we certainly recommend that you do, is address the employee's concerns. Find out what it is. Why is the employee concerned and refusing to wear a mask? And again, this is not a new concept, but if the employee is not raising any legitimate medical or any otherwise protected objection, then what employers would consider doing is to engage in discipline. If it comes down to it, and it's not protected, then an employer goes back to the regular playbook. And this is one violation in the workplace like many others. And it's important for companies to discipline employees in order to protect the other workers. Hygiene, light touch surfaces, that includes lights and power switches, frequently touched surfaces, doors, drawers, collaboration tools, whiteboards in offices, shared equipment, Xerox machine, well, printers, computers that are used by more than one person, supplies. And then again, I mentioned kitchen and meal preparation areas. Many companies at this point are leaving those closed. And then of course, personal work areas where employees are going to have their own either a workstation or an office or what have you. But those are things that the employer needs to be, companies need to worry about, to remind people to practice good hygiene in those areas. And then, of course, internally, sort of from the maintenance perspective for companies, is there are environmental and safety practices and hygiene practices. So it's cleaning, it's performing environmental cleaning on frequently touched surfaces, front desk, elevator banks, coffee stations, doorknobs. The Center for Disease Control is saying you don't have to do additional disinfecting beyond your routine cleaning. But again, we always recommend, this is such a slippery topic. So many of these issues are being rewritten and revised. We're always going to say, check with the website for the Center for Disease Control. See if there's anything new, because this stuff does continue to evolve. And then, of course, there are now products that have EPA approved, cleaning solutions that are supposed to be effective against COVID-19. And again, that may be required if you're in a position in your companies to do clean linens, laundry, those types of issues. So here's an issue that we're going to turn to, because what do you do for COVID-19 tests? A lot of us are dealing with these issues. In fact, I was dealing with a client of mine this morning on this very issue. And the issue becomes, can you, an employer, administer a COVID-19 test, which is a test to detect the presence of the COVID-19 virus before permitting employees to enter the workplace. Now, here's the issue. Under federal law, which is the ADA is a federal law. It's under the Americans with Disabilities Act. And under the federal law, you are allowed to administer a COVID-19 test. But there's a hitch on that. It has to be job related and consistent with business necessity. So what does that mean? So in this world we're living in, it is likely to be the case that since employers are concerned about protecting other employees, their customers, their clients, there's likely to be a fairly straightforward determination that an individual with the virus could pose a direct threat to others. So that's on the federal side. But on the California side, it is just not clear at this point whether a company can actually require a COVID-19 test. And here's what we think, but we don't know for sure. But we think that more likely than not, that under the federal law, it is likely, but we have no certainty as to whether or not, but we think it's going to be allowed under California law. But I just can't just bookmark that because it's just not clear. And then of course, employers have to make sure that the tests are accurate and reliable. This stuff continues to evolve. There's different types of tests, but you have to look to the U.S. Food and Drug Administration about what's safe, what's not, what's accurate. The Center for Disease Control has put out guidance. Our local authorities, counties, the public health authorities, they are revising their guidelines. Some counties are doing these things differently. And so you need to be constantly on alert to see if there have been changes to these. And then of course, just with respect to the tests themselves, there are issues with respect to whether it's a false positive or a false negative. A test is only a snapshot in time as of the time that the person was tested. So a negative test doesn't mean that that you may or you may not acquire the virus later. It's just that moment in time. I have to mention a little bit about OSHA. That's the administration that administers workplace injuries and accidents and safe workplace practices. And here in California, we have our own version of OSHA. But one of the things we know is that as it's now standing under the law, COVID-19 is really a recordable illness, which means that companies are responsible for recording cases of COVID-19. If there's a confirmed case in the workplace, it's work-related, and there's one or more general recording criteria that's set forth. So I'll just mention it's beyond the scope of this presentation, but all companies, whether they're big companies or small companies, all companies are required to have injury and illness prevention plan. And if you, assuming you have one and it hasn't been updated in a while, or even if it has been updated in a while, it is now very clear that all injury and illness prevention plans are going to have to be updated because it's a new issue in the workplace. And if you go to the Cal OSHA website, you'll see some protocols with respect to how the injury and illness plan needs to be updated. So again, OSHA has to look at whether, and Cal OSHA for that matter too, will look at what's the reasonableness of the employer's investigation, the evidence available to the employer, whether COVID-19 was contracted at work. Now, there is a new executive order that Governor Newsom signed into law a couple of weeks ago. And under certain circumstances, there's now a rebuttable presumption that if someone contracts COVID-19, there's a rebuttable presumption that it was contracted in the workplace, making that employee also eligible for workers' compensation insurance. So I wanted to mention that just as one other issue for companies who are dealing with this stuff. So what do we need to do if you know someone has tested positive? What do you tell your employees? Well, you should disclose to coworkers that an employee is tested positive. You should not identify the employee by name, but because that's now private information from for the employees, and employees who are infected still have rights to privacy. But you should ask the employee to provide you a list of everyone that they've come in contact with in the workplace. And that would be other employees, clients, contractors, vendors, because you want to be able to trace back. You want to be able to see if there is a much bigger problem in your workplace. And of course, you should notify any individuals, all individuals that have been identified by the employee that someone they were in contact with tested positive, and they should take appropriate measures. Protecting others, also a big area. So this is again part of it. You need to identify contacts, interview the likely infected employee to know who their coworkers are, who they've been in close contact with. Again, I said notify, locate, contacts. You have to tell potentially infected people of a potential exposure. If folks are self-quarantining, you need to periodically check in with them to determine if they've developed any symptoms. And then, as I mentioned before, employees in our workplaces have rights to privacy. They have rights to privacy in their medical information. So to the extent that companies are taking action, we still have to be mindful that we have to protect the privacy rights of individuals about an employee's medical condition. And it needs to be shared very judiciously, only on a need-to-know basis. And again, you need to identify where the employee works, where are all the work areas. Those areas probably should be closed to other operations. If you're going to bring in an outside company to thoroughly clean and disinfect, that is most likely going to be required unless you have in-house expertise, and you'll have to use chemical solutions sufficient. And then, of course, you need to consider whether you're going to engage in enhanced screening protocols and distancing. Temperature screening, that's another big area that we're talking a lot about. So you need to consider whether you do temperature screening. You need to, again, review your distancing arrangements and increase distancing between employees and work areas, break rooms, common areas, to that at least 6 feet in all work area. And here's the other thing is the you know, you need to review your company policies on what kind of PPE and face coverings, and think about whether or not those have to be increased in affected work areas for at least 14 days. Returning to work. This is an issue that now we are seeing, there's coming up a lot. It's determining what steps you must take in order to return an employee to work after an employee is tested positive. And again, it's not one size fits all, and it's going to depend on a lot of circumstances, including the location where the employee works. Now, and again, there's guidance on the Centers for Disease Control. We have the White House guidance on opening up America again. We've got the governor's new California Resilience Roadmap, which has industry-specific guidance. And the governor's Resilience Roadmap has 3 specific stages. We're now in stage 2, which is really, we've done some basic preparation. Looks like now we're talking about gradually reopening of lower risk workplaces, starting with some retail, and we're into part of stage 3, which is allowing, in my county, allowing for higher risk workplaces, including in my area, hair salons, for example. But the point is, you need to look at the different factors. You need to look at local laws. You need to look at what's the burden on the healthcare system. Has the area been affected? Are doctor visits difficult? Is there availability of testing? Would it be realistic to require all employees to be tested before returning? And these are issues that we're all dealing with. And then return to work approaches. There's no one size, there's no one solution, but these are just some of the options that we have. One is just a symptom-based approach where you ask employees to self-isolate, monitor their symptoms for a period of time, then they can return after meeting certain milestones. The time since the illness approach. Many people, not just employees, will contract the virus but never show symptoms. So you may need to require employees to certify at least 10 days after a positive test they've not exhibited any symptoms of COVID-19. And then there's a time since recovery. So if someone has shown physical symptoms, fever, cough, shortness of breath, you may need to require employees to certify they've been fever-free without medication for at least 72 hours, 10 days have passed, at least 10 days have passed since the positive test. And if there's going to be a return to work certification from a healthcare provider, if possible. In California, it's very clear that if an employer is going to require a return to work certification, the employer is almost certainly going to be required to pay for the cost of testing. Now, I know there are testing sites that are supposed to be free for folks to go to get tested. And that's something that you would want to check out, because certainly if there's no cost involved, then that's another issue entirely. But if you're going to require an employee to get a return to work certification, you may have to pay them for the time it takes them to go get that certification, because you're requiring that they do that. And if they do something for the company, they're essentially doing this, as part of their being able to work. And an employer may be required to pay for their time. And of course, the reality is right now the healthcare systems are clogged, and it may not be that easy. Then there's a test-based approach, which is you got to test negative before you can come to work. And that's going to be contingent on whether testing is still available, whether it's spotty or sporadic. And then if you're going to have testing results, the employee should provide a copy. There's still no clear guidance under California law, as I already mentioned, on whether or not an employer in California can really go ahead and require the testing and require a copy of it. We think it's going to be allowed, but the best I can say is stay tuned. And already talked about is going to fall on the employers to pay for the testing. And if the employer has the financial ability, this may be the most likely way to provide some certainty and do the best you can to ensure that employees returning to work won't help spread the virus. Doctor's note, again, we've talked about this already, but can you require a doctor's note? Yes, they're allowed under the ADA, the Americans with Disabilities Act. We are not absolutely certain under California law that they are going to be allowed. We think, given the severity of what's been going on, it seems likely that that would be allowed, but we just can't give you any hard and fast rule because we don't have that yet. Medical screening forms and policies. So we want to look to, there's a number of different resources. The EEOC is the United States Equal Employment and Opportunity Commission. And the EEOC updated their published pandemic preparedness in the workplace guidance for handling pandemics within the scope of the ADA. And with respect to temperature scans, tests, and symptom monitoring, that's generally considered to be not improper medical exams under the Americans with Disabilities Act because they're job related, they're consistent with business necessity to protect employees in the workplace. There are equal employment opportunity laws that still apply. I mean, folks, the old traditional, you can't discriminate against people of a certain race, people of a certain age, people of a certain religion. Those are all still protected, but those laws are not going to interfere with or prevent employers from following the CDC or the state and local public health guidance to the extent reasonably necessary and related to what you're actually trying to do, which is to keep your workplaces as safe as you can be. So there's two different kinds of screening. One is temperature scanning of employees at the start of the shift. We're seeing that. That can be, it depends on what jurisdiction you're in, it depends on what's required, but it can be something that is done at the start of an employee shift. The other way is a screening of employees for COVID, and that's either have the employees self-screen or by the company or bring in an outside third party. So this is not a one-size-fits-all, and it depends on what's going to be required in the specific place where you folks are doing business. Temperature checks, back to temperature checks. The issue with temperature checks is that before coronavirus, taking an employee's temperature would be considered a medical procedure, a medical examination that would be prohibited by the Americans with Disabilities Act and our Fair Employment and Housing Act. But the EEOC and the Department of Fair Employment and Housing has published guidelines saying that employers have the green light to implement temperature checks during COVID-19, during the pandemic, for the limited purpose, and here's the key part, for the limited purpose of evaluating the risk that an employee's presence poses to others in the workplace. And what we're seeing is different state and local ordinances are kicking in, where we're seeing that in San Diego, as just one example, essential businesses and those opened under the resilience roadmap must conduct daily temperature screenings of employees and have specific plans for health screenings, maintain social distancing and sanitation. And employees with a temperature of 100 degrees or more must be prohibited from entering the workplace. Now, I'll say one other thing about entering the workplace and what the temperature is supposed to be. I just said it with respect to San Diego. But we're now seeing that in different localities, what we thought was the threshold, which was the 100.4 degrees Fahrenheit, we're now seeing that that's been lowered. It's 100. Some localities, we understand, have something less than 100. So you need to be aware of what that threshold is for screening your employees. And then, of course, what happens if they fail the test? Do you send them home? Do you allow them to retest? Those are all issues that you're going to have to decide on, based on what you're actually seeing, what's going on in your workplace. Do you keep a record of it? It does become a medical record if you're going to keep it. There's issues we'll talk for a few minutes about. Who should the employee contact about next steps? What's the protocol? What happens if an employee fails a temperature scan? What's the procedure if the employee refuses to take a test or needs an accommodation, or you need to authorize a written procedure? So here's just one sample of possible language which a company can insert into its policies and procedures. And that language is: you've been advised that you have a right to request a reasonable accommodation if there is a legitimate reason why you cannot participate in the health screening, or if you have a non-COVID-19 related health condition that might cause you to exhibit symptoms similar to COVID-19, like a fever. So as I said, we're going to make available to you our HR Toolkit. And I said it before, I'll say it again, that these templates have to be carefully used. You need to check with your legal advisors. You need to check with your HR folks if you have HR folks, because it's not necessarily right for every company. And I'll also mention that my firm is developing some very specific California FAQs, and we will make that available when they're finalized. Because we'll deal with some of these issues and deep dive more into California, and we're putting it into FAQs that hopefully will further guide companies who are dealing with these issues. Again, sample language if you refuse the test. If you refuse a temperature screen, the key takeaway, we're going to treat that as a failure of screening, and we're going to deny you entry to the facility. And then if that employee refuses the temperature test, that employee is not going to be paid for the day they reported to work unless it's required by law. And that's a whole other issue, because under some circumstances, if you send an employee home, then you do have to pay them for the workday or for a part of the workday. But in these times, these extraordinary circumstances that we're living in, it is wise to have a policy that at least lays out what's going to happen if you refuse to be tested and what are the consequences. And then there's this is just a sample, one of many that you could use, but this is one that we have given to companies for their consideration, that provides for a record. And if you do decide you're going to do temperature screening, this is going to be how you're going to, as one version of how you might keep track of it. Employee health screening inquiries. Again, the employees still have rights to privacy, but companies may require employees self-report symptoms, and employers at some level may want to monitor employees' health. So this can be done on a regular basis. You can have a formal process like the health questionnaire, or it can be if you have reasonable belief that the employee may be exhibiting COVID-19 symptoms. And again, you have to be consistent in how you're applying this, because you don't want to, at the end of the day, get accused of treating people differently. That's what disparate means. You don't want to treat them differently because of protected classifications, because of their age, because of their race, because of their religion, what have you. And then again, employees still have rights to privacy. We have to maintain the confidentiality of results of health-related questions, medical exams that are aimed at determining whether or not an employee constitutes a direct threat to the workplace as a result of COVID-19. And that's required by the ADA. But the takeaway for you is if you're going to do these health screenings, you need to do the best you can to make sure you treat that documentation as a confidential medical record. And that includes all points of collecting, storing, transmitting, using, screening the results. You have to safely discard this information. In a sense, it's no different than if you at your company has other information that may fall into the within the areas, the employees' rights to privacy. If you know, for example, their ages already, if you know you have other information about the employees, you may have access to workers' compensation records of some extent. So you already have information that you need to keep private. So this is not a new concept, but it's worth repeating. And again, we have to deal with these policy issues that are going to come up, that employees evaluate screening, testing requirements, recommendations, and there's going to be issues that we've already touched on. Who's going to perform the screening? It's going to be a company nurse if you have one. Is it going to be HR? Is it going to be employee self-screening? Are the screening results recorded or not? How's the information going to be recorded? Daily log sheet I talked about, a separate log sheet. How's the screening information going to be stored? How long? And how much time is this going to take? And is the employee going to be paid for the time? These are all issues that we have to deal with. So here's, again, an example of a self-screening form for an employee to self-screen, and you'll see that it just covers a variety of topics, asking the employee to self-report. And this becomes an important tool for companies to encourage employees to self-report. If they're in the workplace, if they're ill, if they have symptoms, they should not be in the workplace. They should be home taking care of themselves. So that's the other part of this, is employees may want to come to work if they know they're impacted, possibly impacted by COVID. And you want to make sure that you communicate to them very clearly if they're not well, they shouldn't be coming in. And then I just wanted to touch briefly about the FFCRA, the Families First Coronavirus Response Act. And these are employees' requests for leaves, accommodating requests for leave. So under the Families First Coronavirus Response Act, now this passed a number of weeks ago, so hopefully you've now seen this at this point, but just to repeat and to review. So there are certain reasons that qualify for leave related to COVID-19. And these are the 6 factors that allow an employee to have leave if the employee is unable to work. And they're subject to a quarantine order. They've been advised by our healthcare provider to self-quarantine. They're having symptoms. They're caring for an individual subject to an order of self-quarantining. They're caring for a child whose school or place of care is closed. Number 5 is a huge issue for us right now. A lot of our clients, a lot of folks are concerned about, what do I do with my children? Who's going to take care of my children? Or are they experiencing any other substantially similar conditions specified by the U.S. Department of Health and Human Services? Okay. Don't ask me what number 6 is, because at this point, that 6th element has not been defined by Health and Human Services. So we don't actually know, we don't have any more guidance on what that means yet. But the leave policy is you want to keep a safe and healthy workplace. There's qualifying reasons for leave. There's paid and partially paid leave benefits that are available. There's notice requirements for obtaining leave. There's guidelines for returning to work. And the big takeaway, and this is not a new concept of law, is retaliation is strictly prohibited. You can't retaliate against people for taking advantage of their rights to exercise leave. Here's just a sample of policy for returning from leave. And it just states that for return to work, employees have to follow the guidelines established by the Center for Disease Control and Prevention and local public health authorities as it relates to ceasing home isolation practices, that employees returning to work will be restored to the same or equivalent position. And that's an important point, and that's not a new point, because you have to bring them back into the position they've been in, unless they would have been subject to an employment action regardless of leave usage. What does that mean? They would have been laid off? Possibly. Their job was eliminated? Possibly. You would need to, in my estimation, this would be things you'd want to talk to your lawyer about or your HR department about before you decide. And if an employee is exhausted all the leave under this policy and still can't work, then you have to review it. There's still going to be flexibility that's required. What we know about COVID-19 is it can be, some people will be non-symptomatic at all, and some people will get incredibly ill. And so that's why it's necessary to not just blindly follow a policy, but again, the notion of some flexibility. There's case by case, there's other issues to make sure that there's some other protections, there's other rights that might exist. So here's what information from the Internal Revenue Service has put out with respect to how an eligible employer is going to substantiate eligibility for sick leave or family leave credits if the employer receives a written request for leave. Now, let me back up for a sec here, because remember, one of the benefits of the FFCRA is that if you are an eligible employer, then you're going to be able to get a credit to the amount of, for the amount of sick leave or family leave that you've paid to your employees. But in order to do that, the employer has to receive a written request for the leave from the employee, and the employee has to provide some baseline information: the employee's name, the date or dates that you request leave, what's the reason, is it COVID related, and a statement that the employee is unable to work, and that includes telework. Now, I don't know how many of you are able to work telework, how many of your employees are able to telework, but that's another issue as well. And if you have a leave request based on a quarantine order, self-quarantine, the statement from the employer should have the name of the government entity ordering the quarantine, the name of the healthcare professional that's advising of the quarantine. And if the person who's subject to the quarantine or advised to self-quarantine is not the employee, then it's that person's name in relation to the employee. My child has to quarantine. In the case of a leave that's requested based on school closings or childcare providers, then you need a statement from the employee that includes information on the name and age of the child. And one of the important things on this is that if the child is over 14, then there has to be need to provide additional information on there are special circumstances requiring the employee to provide care. And then there's a request for leave form. The Department of Labor has not issued a form. So we're recommending that any request for leave should have the information we just talked about: employee name, date the form submitted, when's the leave requested, what's the begin date, what's the end date, the leave request, supporting reason for the leave. Some circumstances you can substitute other available paid leave benefits, paid time off, for example. And then there's other information the company may request, and timeliness of the employee's response. You just want to have a cap on it. You want to say, we want you to respond by X date, 5 days. And it doesn't have to be cast in concrete, but you just don't want it to slip through the cracks. And then you have to also grant or deny the leave, and that should be in writing. If the employee has leave granted, that should be documented. If you can't deny or grant, and you need additional information, that should be documented. And then if leave is denied, that should be documented. And again, on this, employers need to be careful on denying leave, because you don't want to risk possible exposure to a claim from your employees. So again, it's, flexible approach. It's some things you need to have in writing, you need to require it, but we're just saying, be careful. Keep your perspective, and how we deal with our employees in these times will determine how much your employee appreciates you, wants to continue to work for you. All of those issues are going to come into play. What is going to be the morale of the employee? So all of this is just critically important, maybe even more important now than it is traditionally. But an accommodation request under the Americans with Disabilities Act, these are just some other points on that. You have to decide whether the employee's made a request for an accommodation. They're not always clear about it. They don't say the magic words that I need an accommodation, but there may be a requirement to consider it. So you maybe are in a position to recognize who may be seeking an accommodation under the Americans with Disabilities Act. You have to determine whether the employee has a physical or mental impairment that under federal law substantially limits one or more major life activities, has a record of impairment, regarded as having an impairment. Under California, it's whether the employee has any physical or mental impairment. It doesn't have to substantially limit a life activity. So there's a difference between the ADA and California law. And if it's not obvious, this is not different than other requests under the Americans with Disabilities Act, under the California law. If it's not obvious, you have to ask for documentation to establish the employee's right to receive accommodation. And you have to determine what it is the employee is asking for and whether it's reasonable. Just because an employee is asking for something that seems reasonable to the employee, it doesn't necessarily mean there aren't other accommodations that could be reasonable. And again, it's respond, keep records, put it in writing on what you're doing. One of the issues we talked about already is whether or not there's going to be an undue hardship. The undue hardship is going to depend on what's being asked for and how your company is set up, the size of your company, what it is that's being requested. Because what may create an undue hardship in my business may not create an undue hardship in your business. It's determined by the facts and the circumstances. You want to identify and document accommodations that are offered, why accommodations weren't needed, why they weren't offered. You have to discuss with the employees. It's the interactive process. You have to talk to employees about what are the reasonable accommodations offered, or the reason why you're not accommodating an employee. You're not offering it. You don't think it's needed. And then again, document, document, document. In the lawyer's world, what you're doing becomes evidence. And if we have documentation, if something goes wrong down the road, having documents of communications, having an employee's signature acknowledging the decision, not necessarily agreeing with it, but acknowledging the decision. And then again, protect the confidentiality. These things are confidential. You need to treat them as confidential. And requests for accommodations can be made a lot of different ways. Plain English, orally in writing. They don't have to mention the magic words, reasonable accommodation or the ADA. They can be made at any time during the period of employment. And if there is a reasonable accommodation request, then if you have a form, You want it to say why. What's the specific requested accommodation? What are the limitations, not the medical diagnosis, what are the limitations that interfere with an employee's ability to do the essential functions of the job? How's this accommodation going to allow the employee to perform the job? And what's the expected duration? And then you have to communicate, and document whether the accommodation's been granted, denied, or an alternative accommodation is more suitable. Final point, in my humble opinion, we are going to be dealing with these issues for a long period of time to come. They're still evolving, they're still changing. There are political issues, there's social issues, there's economic issues that will be in play for years to come. Will there be lawsuits and litigation filed as a result of the issues we're talking about today and how we're dealing with COVID-19 in the workplace? Yes. I mean, it's already starting. This is going to be, as with any other emergency that may come up, there will doubtless be claims. And what we know for sure is that all the things that companies are doing, all the reasonable steps we're taking, we won't know for a while. We won't know perhaps for many years whether or not we actually got it right. On that, I thank you for your attention. I know we covered a lot of material, and I think there may be some questions or opportunities for questions.
Yes, thank you so very much, Ed, for your presentation. We are actually going to be transitioning now to the Q&A session. So if you can stop sharing your screen, that would be wonderful, and we'll bring up my presentation. Thank you. On that note, thank you once again, Ed and Gray, for sharing information on employer and employee HR Toolkit in response to COVID-19. We will address questions and answers at this time. I will read the question, and if applicable, the presenter will provide an answer to the question being asked. In our queue, we have one question, and it reads, we are a small startup company of 8 employees in San Jose in commercial space with office area of 2,000 square feet. We have engineers who need to do their R&D work in the lab. My question is if we can resume office operations full time. Thank you.
Yeah, that's actually a pretty specific question. I mean, what I'll say is this, and we covered it in the presentation. What I recommend with respect to resuming operations, because I'm not sure, that could mean a lot of different things, but I would encourage the person who asked that question to check with the local authorities. That could be the county, in some cases it's the city, because they are, and it could be the state of California, because there are various levels of guidance that are being issued by those different agencies. And for certain types of industries, they are issuing their guidance and what's required, including a specific work plan, including requirements before you're allowed to reopen, what steps have to be put in place. So it is very, very, very much driven not only by the type of business, but also by the specific locality in which you have your business. And I think in that question somewhere was some mention of we are in commercial space. And with respect to that, that adds an additional element, because I'm assuming by that commercial space means the space that you rent from someone who's a landlord. And it is also necessary to check with your landlord and building management with respect to what steps they're putting in place. and what they're going to require of companies who are trying to reopen their workplace. So those are generally the things that I would recommend. Again, it's got there's a lot in that question to unpack.
Great, thank you very much, Ed. We have a few more minutes for Q&A, and we have 2 additional questions. The second question reads, I'm a sole proprietor. I'm finding a lot of health and safety resources for business with a lot of employees, but not resources. Ed, can you lend some guidance to this statement?
Sure. Thank you. So that's a really great question because, yeah, a lot of our smaller businesses are challenged. I think Gray mentioned it in the beginning of her presentation. There certainly are resources that are, available to provide assistance to you, and there's lots of resources online, also that are available. And there are also other, and there are other agencies that are also available to assist companies. If we're looking at with respect to from the small proprietor with respect to employees, for example, then you can look to guidance from organizations such as employment groups. If you're looking for guidance with respect to your specific industry, based on what I've seen, a lot of specific industries are developing protocols. But first things first is as I mentioned, we'll make the toolkit available for folks to hopefully that will assist them in providing guidance. Some of these concepts that we've talked about today applies not only to, most of what we talked about today applies to small businesses as well as large businesses. So I suggest you take a look at the toolkit that we're going to make available, the California specific FAQs when they're available. Perhaps talk to Start Small to see what other resources they have. Those would be some places that I would, and my own trade group, trade association, if it's appropriate, if you have a trade group.
Wonderful. Thank you so very much, Ed. We have a couple more questions, and just a very quick time check. It is 4:17. And if you can provide about a minute or 2 in response to these questions, would be great. The third question reads, if an employee has a compromised immune system and doesn't want to return, is that considered a reasonable accommodation?
Yeah, the short answer is yes, if depending on what other factors are involved. So for example, the fact that there's a compromised immune system, there are always issues with respect to, well, what are the risks of exposure in your particular workplace? And can you accommodate that? I mean, the short answer is, I'll analogize it to age. Just because you're of a certain age doesn't mean that you should be excluded from the workplace. So I think it's going to depend on what protections are in place. But the takeaway for me on this is always going really slow and being flexible approaches to employees who may be legitimately concerned about coming back to the workplace.
Great, thank you. And our last question reads, I'm a sole proprietor. Let's see here. Excuse me. I'm a sole proprietor and enter into people's home, and social distancing is challenging. I'm finding a lot of health and safety resources for business with more than one employee, but not resources for single person businesses. Can you point me in the correct direction to find resources?
I mean, if I understand the question, you're going into other people's businesses
or homes,
then the guidance, the concern is just to make sure that you have influence, because there's 2 issues. One is, what's the risk of exposure in the business or home you're going into, and what's your risk of exposing someone to COVID-19 in their space. So I would say you need to deal with it the same way with respect to the guidance. Minimize contact, keep social distance. I would look to the guidance on that. Wear a mask if you're wear gloves. Don't if you don't know whether it's safe or not, don't go in. And then find out what the other employees are doing. So those are, but it's the same resources that we've been talking about. It's the same guidance. It's the same information. It's just, as we say, not one size fits all. So it is the same issues and concerns, just on a more macro safe scale. And you have to implement safe practices for your business and keep your customers safe.
Wonderful. And that concludes our Q&A session. Once again, thank you so very much, Ed and Ray, for taking this afternoon to provide us with guidance on employer and employee HR toolkit in response to COVID-19.
Thank you. It's a pleasure to be here. Be safe, everybody, and stay strong.
Thanks,
Thank
Sandra and Ed and everybody. Thanks again. And
thank you very much.
Thank you.
The following slide provides resources. If you'd like to be a speaker or receive information about upcoming events, please contact Mirza Hanzar at mirza.hanzar@sanjoseca.gov to share topic ideas. In the event you are dealing with business hiring, laying off, or downsizing, please contact Business Service Team at work2future@sanjoseca.gov to gather additional information. All employers, businesses, nonprofits, and workers impacted by COVID-19 can write us at COVID-19 sjbusiness@sanjoseca.gov or call 1-877-880-1222. Once again, you can write us at COVID-19 sjbusiness@sanjoseca.gov or call 1-877-880-1222, and note translation services are available in Spanish and Vietnamese. We'd also like to ask our participants to tell us what you think of of this afternoon's webinar. Please see your email for a hyperlink to complete an online survey. We appreciate your input. Once again, thank you for taking the time to attend the City of San Jose's webinar series in response to COVID-19. For future webinar topics and related resources, please visit sjeconomy.com. Once again, thank you, have a wonderful day, and stay well and safe.